So how do you deal with minority shareholders? There's different ways. But having a shareholders agreement is really a prudent way of doing it. Questions on that? There's no set way. There's no cookie cutter way. It takes creativity.
What was the plan had he not said that he was going to quit?
He knew this guy so well. He had been with him for 10 years, and he knew this guy so well. And I knew the guy pretty well too. He was a hothead. And what he had said to him on Friday, it was a lot more than what I had said. He just went off on my client. And it was a calculated risk. If he had not resigned, we were going to fire him and then just terminate him with cause, kick him out. Because as a majority owner, you always want that right. If you're a 50-50, much more difficult. Question?
But you don't really terminate any cause.
Without cause.
Yeah.
Unless the cause definition is broad enough. Now I've seen it and I've drafted them so that if there's insubordination, that's cause. What is insubordination? It's actually a term defined in case law in Virginia. It's not a statutory definition. So, I mean, there are different ways of defining cause, myriad ways. So I have cause defined in some agreements that is really broad, that gives the founder or the owner the ability to terminate and claw back the equity, basically for nothing, if there's cause. The question is, what is cause? And that's usually a heavily negotiated. The more the person owns, or the more important the person is to the business, the more leverage they're going to have. I've got a call at 2:30 today with one of my clients who started up a lobbying shop. He left a law firm that he was a partner at. We negotiated his departure from the law firm, and it was amicable, and then he started up a lobbying shop. He's bringing 2 of the former employees with him. The law firm was easy to deal with. It's these 2 employees. One of them hired a sharp lawyer out of New York. We had to negotiate all kinds of stuff into her deal. She's a minority shareholder. But he wanted her so bad that he was willing to do anything. I said, this is going to come back and haunt you later on. So we gave her stuff, but we didn't give her everything.
Just to get her on board?
To get her on board.
Wow.
Just to have her come on. So these are the things that go, founders who are desperate to bring on talent to help manage the company may do things in these agreements that you advise them not to, but they say, look, I got to get it done. And they're looking ahead. That's what entrepreneurs do. They don't look behind at what happens if everything falls apart, or there's a disagreement or a dispute. So we've got to deal with it. At some point, we have to deal with it. So the majority shareholder wants the ability to buy out the minority, always, always, under all circumstances. Death, disability, termination with cause, termination without cause, quitting with good reason, because we did something bad to them. Without good reason, they just quit. So you build in those types of protections in the agreements, and then how do you define them? There is no cookie cut. You pull that stuff off the internet, you are doing it at extreme peril. Do not advise a client. In fact, advise them never to do that. They should always visit their attorney about that. And for the minority owner, they have inspection rights. They can't be waived under state law. There's no waiver of inspection rights that I'm aware of. Delaware law, Virginia law, can't be waived. But they can't go on fishing expeditions. So you can limit the rights to inspect, what they can inspect and when they can inspect them. You can limit those rights by agreement. Delaware law allows you to do that. They can only see tax returns, financial statements. They can't go under the books and records unless there's a reason for it. If there's a reason for it that might be the subject of litigation, then their inspection rights will allow them to go behind the books and records somehow. And then, as a minority owner, you always want the ability to be bought out. So if you leave, or if you're fired, you want to be able to liquidate your shares. And the majority doesn't want you holding those shares either. Unless it's a really, really big company, they don't really care about you having 1% or 0.5% interest. I always advise the clients, buy them out. Buy them out.
I've also heard of conditions where if you leave and go to competition, right? Whether you do or don't go to competition.
You know, that's an interesting concept. We're going to talk about non-competes in a couple of minutes and what you do, how you structure these things. But usually in a buy-sell agreement, you want the ability to claw back the shares if they do violate the non-compete, or if they do take your clients, or they do come in and take your employees. You want the ability to claw back the shares. You want the ability to claw back the payments that may have been made already under the buy-sell agreement. That's enforceable in most states as long as it's written properly. And so the question is, what does the non-compete say? And where do you have for the non-compete binding? What governing law applies? Virginia doesn't like non-competes. They'll throw out the whole clause unless it's written in a particular way. We have literally, I was told by one of the labor and employment lawyers, we literally have 5 major cases going on right now in litigation of non-competes or trade secrets, stealing cases upstairs. And it's heavy duty. So alternatives to giving away equity, percentage ownership of the business, that's the way people, quote unquote, used to do it. That's the way some of my clients still do it. I try to get them away from that. I try to get them into synthetic equity, phantom stock appreciation rights. They're virtually the same thing. It's how they're structured. You can pay out somebody the increase in value over the time that they came in. So you set a base value of the date they came in, and you have to have either some kind of formula or some kind of appraisal to set that value. And if you pay them the appreciation in the business, when you sell it or on exit, you can build a plan. It has to comply with Section 409A of the Internal Revenue Code, which is fraught with traps for the unwary. You have to be very careful about that. But you can buy them out of their equity piece, but it's treated as deferred compensation. It's ordinary income to them. The company gets a deduction for it, and it's ordinary income to them. And withholding has to be taken out at the time of the payment. And it's subject to, again, very rigid rules on how you structure these things. And the owner, the founder, can have very little discretion about when the payments occur. Otherwise, you're in violation of this Section 409A, and it's devastating results for both sides. You don't want to do that. So developing a plan like this requires somebody who's familiar with this 409A concept and also how you structure these plans. But it's a lot easier, believe me, it's a lot easier on the owner to have to pay out somebody under this plan than to give them actual equity in the company. Having been through minority buyouts over the years, many of them, I can attest to that. Any questions on phantom stock? We talked about it a little bit last time. So, death, disability, owner disputes. What about when a company faces economic troubles, either due to its own failings or due to what's happening in the marketplace? What do we do? In 2007, 8, 9, it was a devastating turn in the economy, downward turn. And then we had similar situation in 2000, 1999, 2000. And I've been practicing long enough to remember the S&L bust in 90 and 91, and the real estate market just tanked. And real estate investments were really adversely affected. And I've been practicing long enough to remember when the passive loss rules were enacted in 1985. I started as a lawyer then. I've been practicing already as a CPA for many years at that point in time. And that had an impact on the tax shelter industry, which was a huge, huge industry. And I practiced in that area as well. So what do you do when there's an economic downturn or a recession? Or when technology becomes obsolete because somebody came up with a better idea or a better way of doing something faster? Or when the industry changes? We're going to talk about some of these examples. Or if hyperinflation hits, which people are predicting may occur in the not too distant future. Scary. Economists I've been reading all kinds of different economist reports, and some people are predicting that hyperinflation is around the corner, and the stock market's going to tank, and